Thank you, Mr. Cruz. Our next witness is Mr. Trey Pebley. He's the Vice President of McAllen Construction in McAllen, Texas. His firm is a small, family-owned and operated business with 133 employees and annual revenues of around $18 to $20 million. Mr. Pebley is testifying on behalf of the Associated General Contractors, which is the largest and oldest national construction trade association in the United States. Sir, you will have 5 minutes to make your statement.
Thank you. Good afternoon, Chairwoman Velasquez, Ranking Member Graves, and members of the committee. Thank you for the opportunity to testify on how federal regulation over water and wetlands impacts my company and my community. My name is Trey Pebley. I am Vice President of McAllen Construction located in McAllen, Texas. McAllen is a small family-owned and operated business that builds bridges and installs municipal utilities such as water lines, sanitary sewers, and storm sewers. We have 133 employees and annual revenues of around $20 million. I am an active member of the Associated General Contractors of America, on whose behalf I am pleased to represent today and serve in a leadership role on AGC's Environmental Network Steering Committee. AGC is the largest and oldest national construction trade association in the United States, representing more than 33,000 firms. AGC members are engaged in the construction of private and public facilities and are a major contributor to employment, gross domestic product, and manufacturing. I am also an elected trustee to the McAllen Public Utilities Board. This is an at-large position that oversees water and wastewater infrastructure and management in my community. As an elected official and a public steward, water quality is very important to me. In my position, I am challenged to make decisions about how to best protect water quality and the health and welfare of our citizens. And because our resources are limited, I must also make sure the projects we fund are done in a timely and cost-effective manner. That is why I'm concerned about a bill called the Clean Water Restoration Act that would fundamentally expand the federal jurisdictional scope of the Clean Water Act and displace state and local jurisdiction over land and water use. Such efforts would cause significant disruption to the construction industry and adversely affect not only AGC's membership, but also the health and welfare of the general public. Construction projects that lie in waters of the United States within the meaning of the Clean Water Act require federal discharge permits that are both costly and time-consuming to obtain. Many of our projects require permits and have been delayed while we waited for the Corps' district office to issue them. These delays have cost us money. As delays and costs increase, as they will under the proposal, some construction projects will inevitably go unbuilt. In my line of work, this means impeding water supply and wastewater treatment projects that are vital to improving public health and welfare and fixing our aging infrastructure. Other AGC members build highway and transit infrastructure, repair dams, construct flood control projects, and renovate schools, among many other things. Any delay in these types of projects deprives the general public of the benefits they would derive from them. Today, my industry faces a lot of uncertainty regarding whether any one project lies in waters of the United States and requires a permit because the exact meaning of that term continues to be in debate. It can take a lot of time and effort just for the Corps and EPA to make a jurisdictional determination to see if a permit is even needed. Contractors and property owners alike have a right to predictability and consistency in the application of law and need fair notice of what activities are regulated. As the operators of construction sites, both property owners and their construction contractors risk civil and criminal penalties for failure to obtain a necessary permit. AGC is committed to protecting and restoring the nation's waters, but we do not believe that it is in the nation's best interest to put everything under federal jurisdiction in the interest of clarity. The Clean Water Restoration Act would do just that, make everything federal. As a result, any activity affecting any wet area in the United States would be subject to federal regulation. We think this goes too far. So do state and local governments that have long assumed primary responsibility for land and water use. The proposal would give the Corps and EPA unlimited regulatory authority over all waters, period, including groundwater. This is of serious concern to us as underground contractors. Under this expansion, contractors, especially underground contractors like myself, would continually face the threat of legal liability for unforeseen and unpreventable encounters with groundwater. Every trenching operation, perhaps every hole dug in America, would require a permit to avoid risk of violation. Finally, I would like to add a thought on the so-called compromise version of the proposal that the Senate Environment and Public Works Committee approved in June. It still results in the same outcome AGC opposes, fundamentally expanding the scope of federal jurisdiction. I understand that Representative Jim Oberstar may reintroduce this bill shortly and include the Senate's changes.
Time is expired. During the question and answer period, you will have an opportunity to expand on any point that you were not able to make at this point.
Okay, thank you, ma'am.
Thank you.